بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف الأنبياء والمرسلين، على نبينا محمد وعلى آله وصحبه أجمعين. اللهم لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا إنك أنت الجواد الكريم. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another episode in our series on Al-Qawaid Al-Fiqhiyya, Islamic legal maxims. Today's maxim is Al-Ijtihadu la yunqad bimithlihi. Now, in the previous session, we talked about the maxim that Sharia rulings change from time to time. So there's a certain connection between this topic and the previous one in the sense that they both deal with the issue of ijtihad. Sharia rulings are arrived at by this process of ijtihad. So, al-ijtihadu la yunqadu bimithlihi means that ijtihad is not set aside by another ijtihad. What this maxim does is it lays down the parameter for the legal status of this process of the exercise of independent legal judgment, which we call ijtihad. So Islam allows and in fact encourages ijtihad on new issues. And it also allows and encourages re-examination of old issues when new evidence arises, or if there's some basis for re-examining old opinions in the context of new circumstances. But what this maxim is saying is that ijtihad in a current case does not nullify ijtihad that was made in the past about a different case. So let's turn to the meanings of the words that comprise the maxim. Ijtihad, derived from the three-letter root jahada, yajhadu, which means to endeavor, to strive, to put oneself out. And ijtihad means exertion, effort, diligence, has facets of meaning here revolving around that same concept. So in fiqh terminology, ijtihad is the exertion of effort to arrive at a considered judgment about the rule of the Sharia on a particular matter, such that one is satisfied in believing oneself incapable of further effort. So the core issue here is exertion of effort. The subject is the Sharia ruling with regard to some particular matter, and in order for it to be considered ijtihad, you have to exert a sufficient amount of effort. The person who's doing it has to exert a sufficient amount of effort that he doesn't believe that there's any more that he can do in order to arrive at the answer. For ijtihad to be valid, the first issue is that the person who's doing it must be qualified. So this requires, first of all, knowledge of the Arabic language so that the person can look at the text of the Quran and the Sunnah and understand them properly. And some scholars, like Ash-Shatibi, he said that the person who does ijtihad should reach the level of mujtahid with regard to the Arabic language. Not simply that you're familiar with the basic rules, but that you know the language on such a level that you can make independent reasoning about which opinion, grammatical opinion, is stronger and which is weaker, and you can make those determinations based upon knowledge, not just because you're following somebody. So that level of mastery of the Arabic language is exceedingly rare. That's why this idea took root in the Muslim Ummah at a certain point in history that the doors of Ijtihad are closed, because people looked around and said, we don't find anybody on the level of Abu Hanifa or Shafi with regard to the necessary qualifications. But the need for Ijtihad continues. New things are always coming up, so we have to make do with the best that we have. And one of the ways to make up for that deficiency in the individuals involved is that Ijtihad in the modern era should be a collective process. And that's what we see in the fiqh academies, like the Islamic Fiqh Academy, Majma al-Fiqh Islami, of the Organization of Islamic Cooperation. So that's based there in Jeddah. They meet every 2 years, I believe, and they assign people at each meeting to do research on specific topics, and then 2 years later they come and present their research on an issue, and then those scholars, there's supposed to be one from every Islamic country, the scholars who are present, they then discuss all of the research that's been presented on that issue, and they arrive at some kind of a decision about the matter at hand. And sometimes they decide that, hey, we still don't know enough, so let's commission some more research. This matter is too complicated, it has to be investigated in greater detail. So that's a kind of a digression here. We're talking about the qualifications of a mujtahid. The first one is mastery of the Arabic language. The other is a strong working familiarity with the text of the Quran and the Sunnah. There were some classical opinions that the mujtahid must have memorized the Quran and must have memorized a certain number of hadiths with the isnad. That doesn't seem to be the dominant position. The person doing it has to be familiar enough with the sources that when an issue comes up, he knows where to look for the relevant evidence. That's the minimal level that seems to be the dominant, the majority opinion about what that qualification entails. Another major aspect of the qualification is that the person should have a real knowledge of usul al-fiqh. Now, a great portion of usul al-fiqh is comprised of linguistic issues, so that goes back to the Arabic language. But there are other aspects of usul al-fiqh which are not linguistic. They have to do with what is the authenticity of a given class of evidence, how much legal weight does this class of legal evidence have, and knowing that for all the classes of legal evidence, and then knowing how to rank evidence so that this is very strong, this is less strong, and how to deal with real or perceived contradiction between given items of evidence. So these are some aspects of knowledge of usul al-fiqh. And what has become recognized as an allied but independent discipline with usul al-fiqh is maqasid al-sharia. What are the objectives of the sharia? When looking at the laws of the sharia, looking at the sharia as a whole, there are certain objectives that the sharia intends from its laws. So knowing those objectives is a critical qualification for knowing how detailed evidence applies to given situations. And then when we're looking at what goes on in the process of ijtihad, one aspect of it is looking at the texts to determine the meanings. Now, most of that process has already been done. Every now and then, we can revisit certain texts and see something in them that people didn't see in the past based on something new that's happened. But the basic understanding of what those texts mean, that's what our intellectual legacy. We have this huge, rich intellectual legacy which the scholars of the past have bequeathed us. The other aspect of ijtihad is knowing which rules apply in a given situation. Sometimes there may be a rule that applies to a given case, and another rule that also is relevant to the case. And so, which one of these rules should be given dominance in this case? That's another aspect of ijtihad. And part of deciding that is knowing that, what are the effective causes of the rules? Are those present in this situation? What are the conditions? What are the impediments? When all of those are examined for a given situation, then as a preliminary ruling, one could say that, okay, this rule applies in this situation because this checklist has been passed. Okay, we're going to take a break and come back, inshallah.
Assalamu alaikum. I am Ja'far Idris. You are watching Peace TV, the solution for humanity.
On Peace TV.
Images and depictions of our Messenger Muhammad sallallahu alayhi wasallam have spread around the globe.
May endless blessings be upon thee.
His life is being examined in the glare of the global media spotlight. It is the duty of every Muslim to present to the world the truth of his life and the excellence of his character.
And we have not sent you, O Muhammad, except as a mercy to the universe.
To do this, you have to know your Prophet. It's something that you simply can't afford to be ignorant of.
Send your peace on your slave Muhammad.
Study the exemplary personality of our Prophet, peace be upon him, which attracts people of all faiths and nationalities in Know Your Prophet, peace be upon him. Every Tuesday at 8 p.m. and repeat telecast at 8:30 a.m. India on Peace TV.
Assalamu alaikum wa rahmatullah. Welcome back. So we're talking about ijtihad, the qualifications for ijtihad, and the situations in which it applies. With regard to this latter, ijtihad is not allowed where the rule is clear and explicit, authentic text, the wording is explicit. That's not a place where ijtihad can be made. Ijtihad applies where the rule is ambiguous, and very pertinently when new things arise, new situations arise that are not addressed by a specific text. Now, speaking earlier about these fiqh councils, these fiqh academies, where a body of scholars comes together to discuss an issue. And a point that I had forgot to mention in discussing the first maxim that was discussed in this whole series, which is al-hukmu ala shay far'un an tasawwurihi. Passing judgment on anything requires understanding it. We live in a world that's incredibly complex, and if a person focuses all of his energy just on becoming proficient in Arabic language and usul al-fiqh and maqasid al-sharia, you can spend a whole lifetime in that and not reach the end of it, for sure. So what if you're asked a question about medicine? You don't have the time to study medicine. What do you do? In that situation, what those fiqh councils do is they call in a medical expert, or two or three, and they say, okay, explain to us, when this happens, what's going on here? So you have to have a collaboration between technical experts and sharia experts on a lot of contemporary issues in order to arrive at that thing that's called tasawwur, proper understanding of the matter for which a rule is being sought. That was all explaining the word ijtihad. Then the second word in the maxim is yunqadu, which is the passive voice of the verb naqada, yunqidu. That has a meaning of demolish, that's in physical terms, to tear down, but it also means to quash or to reverse or rescind, for instance, a judge's sentence, to repeal or revoke, to nullify, declare void. So it's these latter abstract meanings that are intended here. So the overall meaning of the maxim again is that ijtihad in a case in the past cannot be overturned. The ruling in that previous case cannot be overturned by ijtihad in a new case. So that ruling in the new case at a later time cannot be applied retroactively to this previous case. So now this has its most direct application with regard to judges. It also has an application with regard to rulers. Now in the time of the Sahaba, Abu Bakr had certain policies in place, and Umar came along and he changed some of those policies. And he made rulings in cases similar to cases that Abu Bakr had passed judgment on. And in none of those situations was Umar's decisions applied retroactively to the cases that Abu Bakr had judged. And that became an established principle. And if you look at it from a rational point of view, the purpose of people coming to judges for rulings is to settle their cases. If you can never be sure that your case is settled, that something will come along later, somebody will make a judgment about something later, which then will be applied retroactively to your case, then this will impose incredible hardship on people. It will make the system of life unstable. And this kind of hardship is detested by the Sharia. So to have ijtihad being overturned by later ijtihad would be against this principle of the Sharia. Now, this maxim also applies to muftis, and in our time it also applies to regulators. So particularly in the sphere of Islamic finance, you'll have like national Sharia boards, places like Malaysia or Sudan. So they make a decision today which changed a ruling about something that happened earlier. People that took actions based on that earlier ruling, their actions are considered to remain valid. They're not invalidated because of the later ruling. With regard to Umar ibn al-Khattab, he made this famous statement that he passed judgment on a case regarding inheritance. And then a similar case was brought to him some time later, and it was the same kind of number of heirs and the types of heirs, and he passed a different judgment. And people said, wait a minute, you passed a different judgment earlier, and now this is a different judgment here. And he said, تِلْكَ عَلَى مَا قَضَيْنَا وَهَذِهِ عَلَى مَا قَضَيْنَا. He said, that was according to what we ruled, and this is according to what we ruled. So in other words, I changed my mind. So he changed his mind, and that's valid, but it didn't affect the past ruling. Now, why would a mujtahid change his mind? Maybe he becomes aware of some new item of evidence, or he looks at an item of evidence that he knew about in the past, but he interpreted it in a different way. Some new angle of interpretation occurs to him. Or he is looking at the relative weight of different items of evidence relevant to a given case, and he decided that, wait a minute, this item of evidence is stronger than I originally thought. So these are all the kinds of considerations, and there are others besides, that would make a jurist change his mind about a ruling. If we look at some of the applications of this, don't even apply to a judge. Even an average person on some level sometimes has to make ijtihad. And the kind of cases where a layperson would have to make ijtihad is what is called tahqiq al-manat, to know that the thing that's related to the ruling is present in a given case. So the classic example of that is you're traveling, you're in a place you don't know. Let's say you're at the airport in Seoul, South Korea, and it's time to pray Asr, and you don't have a compass with you, and you're trying to figure out which way is the Qibla. So it's a cloudy day, you look out, you can't see, and so you go to somebody and you ask them a question, which direction is east or west or whatever, and then based on that, you determine, okay, well, Qibla is that way, and you pray. Okay, and you have a long layover. So now it's Maghrib time. And for some reason, let's say the clouds break, and you see, just as the sun is setting, that, hey, that guy said that this direction was west. Well, west is actually this way. So the time has gone out. You know, there's no time to pray that asr. You discovered that the direction you prayed in was incorrect. What do? The majority opinion is that if you discover the true direction after the time has gone out, then your ijtihad in that earlier case, you did the best you could, and your salat is valid. You don't have to repeat your salat. In the classical era, judges would adhere to a given madhab. And sometimes a case would be listened to by a certain judge, and then some other issue related to that case, it would be a continuance. It would come before a different judge. So whatever the first judge ruled on related to that case, the second judge, you know, this was a point of agreement among all the schools of law. The second judge would not be allowed to overturn the decision of the first judge regarding that aspect of that case just because his madhab disagrees with the madhab of the current judge. That was a principle that's well established. If you look at the modern application of it, we've talked about this issue of stocks that are listed on stock exchanges, and in Malaysia, as an example, and other countries also have this, you have a Sharia advisory board to the Securities Commission. And so they look at every single stock that's listed on the exchange, and they say, okay, this stock is Sharia compliant, passes the screening process. This stock is non-Sharia compliant, therefore Muslims should not purchase its shares. Well, the characteristics and the activities of these companies, they change over time. So the Sharia board, the Sharia committee, it goes through a review process on some regular basis. They re-examine all the stocks. And some of the stocks that were classified as Sharia compliant last time, they have changed and they're now Sharia non-compliant. So the listing now goes up that company A is no longer Sharia compliant. Well, you know, there are individuals and companies that bought those shares when it was considered Sharia compliant, and they earned income on the dividends from those shares. What are they supposed to do? The current Ijtihad does not overturn the previous Ijtihad. So any income that was derived before the new ruling is considered lawful for those shareholders. If the status then changes, then, you know, they are given some sort, like a window of time in which that they should divest themselves from those shares. And a similar kind of a situation just with regard to a Sharia body. So let's say you have a national Sharia body that deals with Islamic banks, and each bank has its own Sharia board. So the Sharia boards at the bank level, they've disagreed about a certain kind of product, and some of them consider it lawful, some consider it unlawful, and their banks then undertake activities based upon those rulings. And eventually it's referred to the National Sharia Council, and they issue a ruling. Then that becomes binding upon all of the banks, but whatever actions that a particular bank did in the past based upon the ruling of its particular Sharia committee, those activities are considered to have been valid, and it's only after the new ruling is issued on the national level that it would affect the activities of those banks. Okay, we've come to the end of our time. Thank you for your listening. Assalamu alaikum wa rahmatullahi wa barakatuh. Allahu a'lam.